My name's Gabrielle Stritch. I'm an attorney, mediator, and collaborative lawyer. I emphasize elder law, estate planning, and family law. And today I'm going to be talking about, well, if you don't have a will, who gets your assets? And what are some alternatives and legal implications of living together, especially when you are in the more mature age category? So a lot of people think when I just talk to them in a conversation that if you don't have a will, your money goes to the state, to New Jersey. And most people are not all that pleased by that idea for lots of obvious reasons. And is it possible that your money will go to the state? Yes, but there's a lot of other people in line first. So when you die without a will, it's called dying intestate. And that means the statute says who gets what. Now, a lot of people say to me, well, I'm married, so everything will just go to my wife, right? The answer is probably not. What do you mean not? Well, there's other people that have rights. If there's a child of your spouse that is not your child as well, they have rights. If there's a parent, they have rights. And so, for example, if you're in one of those situations, then the spouse would get 25%. Well, I have the number here somewhere. The spouse gets 25%, no less than 50,000, but no more than 200,000. And then other people get their dibs in. So if that's not what you want for your spouse, this is a heads up. Get your planning done. And we're in a really tough time. There's over 250,000 people that have died from COVID in a matter of months. Don't be a person that gets it and realize with panic that you never did get around to doing this. The best thing you can do is just to make a phone call, set the appointment, and then it will happen. Okay. So how does your money get distributed? Well, somebody has to be assigned as an administrator. You only have an executor if there's a will that designates someone as an executor. Well, what's the problem with an administrator? Well, first of all, everybody that's a potential beneficiary must be notified formally, certified mail, regular mail. And they can object, and it's very easy to object. It's just this little form that you fill out at the surrogate's office. And if they object, now you're into a whole will contest, and what a mess and expense that is. Then all administrators, without exception, must get a surety bond posted for them. And the value is the value of the estate. It's expensive, it's time consuming, and you need nearly perfect credit. And the reality is not many people have perfect credit. So even if you think, okay, I'll take care of my aunt, maybe you won't be able to, because maybe you had a medical problem, you got behind on your bills for a while and it impacted your credit. So whoever is the administrator or executor, as a matter of fact, must survive the decedent by 120 hours. I will tell you that most commonly what I do is I say 30 days. I want it to be really clear cut. So now you'll notice here it says all to surviving spouse or domestic partner. So who knows what a domestic partner is? Can anybody tell me?
Someone you live with, living together?
Barely living together does not make you a domestic partner. You must actually register like you would for a marriage license, and you get documents. And if you want to break up, you have to go through a domestic partner divorce. Now, the rules are different as to what everybody's entitled to, but you will see here that a spouse or a domestic partner is very favored. And in fact, they're what's called Class A beneficiaries, which means no estate tax under New Jersey. Anybody know what the story is on estate tax at the federal level? Dave, you're shaking, no? Okay. Yes, there is a state tax that's very serious. It's like 45%, but it doesn't start till approximately 11.5 million today. Now that is going to sunset. Anybody knows someone that has more than 11.5 million per person and they need to refer them to an estate planner, attorney, then I will buy you lunch for such a person. I know, big generosity, right? Okay, so we talked about this 25%. And then in New Jersey, if there is no spouse or domestic partner, then it goes by degree of kinship as defined by New Jersey. And you'll see the parents, get parents and grandparents actually get preference. Wait a minute, it says grandparents. What if they get some money from this and they're in a facility? Is there a problem with that? Oh, yeah, big time. If they're on Medicaid, they'll get immediately disqualified. All the money has to be paid out to the facility, and then you have to get them requalified. If anybody's done the 50-page Medicaid application, you're going to think, ooh, I don't want to do that. Okay. Now, if you don't have a surviving spouse, you don't have any children, you don't have any parents, you don't have any grandparents, you don't have any decedents of grandparents, and not even stepchildren that are alive, then everything goes to the state of New Jersey. So to summarize, why should you have a will and other planning documents, if I may say so? Well, again, it's going to be your wishes instead of just some arbitrary scheme made up by some legislator. Now, I have had a person come see me. He made an appointment. I forget where he found me, online somewhere, something like that, not a whole relationship thing. And I like to do my wills in person. And we talk first, and then I put what I start with as a form on the wall, and I go through paragraph by paragraph, and we discuss options, concerns, everything. I draft while we're discussing it, make sure every paragraph is understood and there's choices being made by the client.
Okay. Gabrielle, can I just interrupt a minute? I understood you to say that if there's no parents or grandparents or spouse or children, that it goes to the state?
Yes.
It doesn't go to cousins and so
forth? No. It's degree of kinship. So you have to look at the statute. I didn't list every single thing.
Okay, I inherited money from a cousin I never heard of.
Well, that's a nice surprise.
That was a lovely surprise, let me tell you. It was a very lovely surprise. And
you don't pay tax on it, which some people
didn't pay tax on it. Yes.
Right. That's a double lovely surprise. Okay. So
I just wondered if that was California law or
no. It's true here too. That is part of the degree of kinship. Okay. So I'm meeting with this guy. I met him 10 minutes ago, and we get to the paragraph on an executor because he's doing his will. So he's going to have an executor. And I said, who would you like as your executor? He says to me, you. I said, me? I've known you for 10 minutes. How can I be your executor? He goes, there isn't anybody else. I said, oh, come on. I start going through the checklist, right, that you were just referring to. No. I said, well, what about an accountant? Oh, I've done my own taxes all these years. No accountant. What about a really good friend that you trust and would do the right thing and follow the will and do it timely and properly? Nope, nobody. What about a girlfriend? No, absolutely not her. Okay. So guess who it was? Me. Okay. So then we get to who he's going to live it to. And, I didn't want to tell his girlfriend, but he didn't leave her anything. Anyway, he decided he wanted to go to charities of his choice. And that's a very common choice for people that do not have any relatives or any friends or anything like this person. Fortunately, they're fairly rare. I've had a few. And they want, there's certain charities that mean more to them, and that's awesome. So I personally would much rather my money go to charity than the state of New Jersey. Much as I love New Jersey, I would rather it go to help other people. Okay. So you get to pick the executor. They don't have to qualify for a bond, and the cost of the bond doesn't have to be spent out of your estate. And you can provide, in my simple wills, I include children and grandchildren. I create trust within the will for them. Because obviously someone's 18, they can't get the money outright. And many times we actually make the trust last a lot longer because the human being is a very complicated person, a complicated entity, I guess you could say. Because our brains, the cognitive part of our brains, don't fully mature on average until age 29 or so. So what we see happen, those of us that do probate work, if somebody, say 20, gets $100,000, what can any of you guess what they do with it?
Buy a car.
Oh, how did you know? That's what they do. Even women do it. Men tend to get a fancier car, but that's what they do. They buy a car. And you know what? Getting a car is not a bad thing, but I sincerely doubt that's going to be a Honda Accord or some other sensible car that they choose, right? So typically what they do is they get, some fancy car and they crack it up within 6 months. So not a good, most of us would not want our money to go to that. But of course, the money can be spent for college. I mean, you specify what you're going to allow the trustee to pay for. And it doesn't mean the money's not available to them. It just means there's a grown-up, a gatekeeper, checking on what really makes sense. For example, I had a client that I was trustee for, and he came to me and says, I want money to go to flying school. I said, okay. I said, the good news and the bad news is I did a little flying school myself. So I'm quite aware of what's involved. It's really hard, really, really hard. Most lawyers are not good choices, even though we're logical. Somebody that is very mathematical or engineering oriented is really a better match to flying school, in my opinion. But I said, look, I don't want to deny you the money, but I have to be prudent about it. How about we have you go see a person that does tests and evaluations, and she's a psychologist, and she will come back and tell me that it's like that you have an aptitude for those kinds of things, and it would be likely that you would complete the course and it would make your life better. He says, I'm not going to any evaluation. I said, oh, the trust will pay for it. It won't cost you anything. I'm not going. Well, how interested are you if you're not willing to spend a few sessions with, and this psychologist I know that does this is absolutely lovely. Everybody I sent her to loves her. They think she's great. No, he wasn't. I said, well, it doesn't sound like you're too serious for me. And flying lessons are very expensive. So I can't approve them if you're not willing to do that. So that would be an example. Maybe you agree with me, maybe you don't, but that's an example of an adult gatekeeper asking questions as to whether the expenditure makes sense. Special needs trust. Unfortunately, there's a significant population, especially in New Jersey, who have special needs. And you do not, and there's benefits that are available to these people, governmental benefits, that all the money in the world can't replace. Like the right answer for them might be a group home when they grow up. Well, you can't just provide a group home, right? Even if you're a millionaire. You really need government resources to do that. But if they have money in their own name, they're not going to qualify. So what you can do is put money in a special needs trust. And of course, there's limits on what can be paid out from a special needs trust. But you could literally have $10 million in a special needs trust, and the person would qualify for governmental benefits. So, we would talk more about that. And this may become true now that we're getting a Democratic president, because the limits are highly likely to change. I don't think it's going to stay at 11.5 million. I could be wrong, but I don't think so. It may be that, we used to have, when I started all this, the limit in New Jersey was $675,000 of your augmented estate. So let's say you have a house, who has a house in New Jersey that's worth less than $250,000? There's not a lot of them out there, right? And then let's say you have $500,000 life insurance, and at today's rate, that's not that much money at all, right? And when you die, that's $750,000 right there. right? Without anything else. And in New Jersey, the max used to be 675,000. So one way we did it is we put the life insurance into a trust, and then it was no longer part of your estate. And it's not like you were really planning on using it, right? It's not an everyday use, the life insurance trust. So a lot of people were comfortable about, sort of putting it beyond their personal reach, as it were. Guardianship. If you know anyone that has a special needs child, the minute they turn 18, they could still be in high school, or they might be out of high school. Somebody must have a guardianship over them. So if they have to go to let's say they're 18 years old and one day and you don't get around to it. If they go to the hospital, the parent has no say in what is to be done and not done, and they're not even entitled to get medical information. And the hospital doesn't know the parent from Adam, right? So they're not going to be empathetic. Maybe the local doctor you've been going to for 18 years would be empathetic and feel that they could listen to you and tell you things. The hospital's not going to do that because it's a violation of HIPAA. They do that. So anyone that has a child 18 or older that really can't make decisions for themselves must get a guardianship. You can't do a power of attorney because they don't have the competence to do a power of attorney. Okay, and a lot of people have stuff that's very important to them. The painting they inherited from their grandparents, the vase made by so-and-so, whatever it is. Or my parents actually have an Eskimo collection. How do you like that, Eskimo? That is museum worthy and in fact regularly exhibit their stuff in the San Diego Museum. Well, obviously it has some real value and specialness to it, and we certainly we want the right people to get whatever they want. So if you want to avoid a fight between Susie and Johnny, your kids, you might want to specify those kinds of items, who gets what. Now, a lot of lawyers will say, just write a list. I don't do that. I don't agree with it. I tell parents to think about it and come up with something now. Why? Because people never write the list. They tear apart the house looking for this alleged list, and it's never done. You want to add to it, you can always add to it. You can always either do a codicil, or you could then do the handwritten list and ask your executor to honor your wishes. And if you have the right executor, they will. So, but when you come to me, I tell you to be prepared. If you have special things that you want to go to a particular person, let's just get it in there. Okay, and we talked about the unified tax credit, which is really 11.5 now. And the reason it's more than this particular screen, which I didn't alter, sorry about that, is there's a yearly increase built into the law. And we've talked about Class A beneficiaries. If you're a Class A beneficiary, which I'll go over who that is later, there's no estate tax. Now, if you need to leave money to a cousin, Carol, then the estate must pay an inheritance tax in New Jersey from $1, and it's approximately 16%. Okay, so what if you're just living together? How does that work? Okay, so you can't imply cohabitation or commitment or anything in New Jersey anymore. There's specific legislation that eliminates that category, unlike California. Okay, so if you just want to show you're committed to somebody and not worry about any legal implications, you can do a little ceremony called a commitment ceremony, and it leaves you single just like you were before you did it. But you kind of told important people to you, we're committed to each other, and that, this is how we feel. Fine. Let's say you want to get married, but you do a prenuptial agreement because at this stage in your life, you want your money to go who you want it to go to and whatever, right? So if it's done properly, both parties having attorneys, you have to have exhibits showing all your assets and liabilities. then generally speaking, it is upheld in the courts if you ever get a divorce later. But if one of you needs long-term care, and I remind you that 70 to 75% of us will need long-term care, then, and you have to go on Medicaid because Medicaid's $13,000 a month and that goes through your assets rather quickly, then the Medicaid will not honor a prenup agreement. And because it's partially federal, it overrides New Jersey law on prenuptial agreements. Okay. Well, what else can you do? Well, what you can do is called a domestic partnership. You can't just do it because you're best friends with the guy in the next state over. No, you have to be living together. And you have to show there's some joint finances together, welfare. You have to have some things together that may be a joint account, some joint, maybe buy a TV together, something, right? It's not considered married. You can't be related to this person. Now, this is available to someone who is of the same sex, unless you're 62 years or older, in which case you can be a heterosexual couple. You have to file, I told you, with the municipality, you have to file an affidavit of domestic partnership. Most insurance plans will then cover you. So let's say and this is a common reason to do domestic partnership for more mature adults, that, now you may get this wonderful level of coverage with one person that maybe has retiree benefits, right? Now, you have to check. Not all plans will do it. Now, the big thing under current law is even if you do this and you are able to get inheritance from the other person as a Class A beneficiary with no tax from New Jersey, and if it's under 11.5 million, no tax from federal government, at the current time, you're not responsible for the long-term care costs of your domestic partner. If you're married, yes, you are. You are responsible. And you have to spend down, not down to zero, but down to just, it's around 121,000, which if you have, say, 500,000 in IRA money, 120 doesn't sound very good to you. So right now, you don't have responsibility for their debts and you don't have responsibility for their long-term care. So I think it's a very viable alternative for a couple that doesn't want to get married, but, wants that commitment and, wants some of the benefits that are discussed here. So what are the legal documents you should have? Obviously a will, that's what we've been talking about. If you're 60 or older, in my opinion, you should have what I call a complex power of attorney. It has Medicaid planning in there. It has HIPAA rights in there. It has gifting in there. All that is looked at very individually when we're drawing it up. It's not just a form. And you should have an advanced healthcare directive, also known as a living will. If you have a son or daughter that you've named as your representative, your medical representative for this purpose, or a spouse even. I've had many of those people in my office crying, well, I think this is what they wanted. I didn't know. It was so difficult to make the decision. And so many times you think you're just, oh, you can do it. You've had this conversation. But when you have to actually tell the doctors to pull the plugs, as it were, that is awfully difficult, awfully difficult. As I may have mentioned, my one brother is a medical doctor, and he's the closest to my parents. And, he's the one, there wasn't a formal living will, but there have been many discussions where my parents made their wishes very clear. And when my father could no longer swallow anything, the choice was to lay there in bed with a tube and not be able to talk, and what that means in terms of quality of life, versus just let it go and let nature take its course. And we were all really clear that's what my father wanted, but it was really hard on my brother because his whole career was about saving people. And now his own father, he couldn't save. So it was very difficult. And a lot of people don't know about PULSE. Does anybody know what PULSE is? No. So a PULSE applies if an ambulance is called for you. Currently, the law is that the people in the ambulance must do everything they can to keep you alive on the way to the hospital. And if you're 20 or 30 or 40 or 50 or 60 even, that may be what you want. You want to stay alive. You don't want to just be let die if an ambulance gets called. But if you're 85, maybe that's not what you want. You know, you're not going to kill yourself or anything, but you don't want unusual measures taken to keep you alive if it's time, let's call it. So there's this special form. Every state has its own. You can go online and Google it. It literally pops up. You print it out, and you must do it with your doctor. And it says to the ambulance, no, you can take me to the hospital, but don't be taking extra measures in the process. Whatever happens, happens. And you need to leave a note about your PULSE, where to find it, and that you have one, kind of prominently on your refrigerator or something, so that they know to look for it and get it. Okay? All right.
I have a question, Gabrielle.
Yes.
So when you go back to the living will or advance directive, and so someone like your brother is, or yourself is left in charge, how do you kind of express in that, reasonable efforts, but not excessive efforts? And if we use the case of your father who passed, maybe putting him on a feeding tube would be considered excessive, maybe it wouldn't. So what's kind of the way
I address each of the most common methods right in my form, unless, that's the difference between pulling something, getting a paragraph from the hospital or pulling something off the internet. All those kinds of details are discussed and addressed in the living will that I do. Like some people will say, well, I want antibiotics, because sometimes what happens, it's very common to get a urinary tract infection, men and women in the hospital. And when you're older and you get a UTI, it often impacts you mentally. You could be out of it. But if you get the antibiotic, you might be fine and totally competent once you get it. So of course, it all depends on the circumstances, the person, et cetera, et cetera. But we go over each of those kinds of things and we discuss, do you want this? Don't you want this? What does it mean? Are there examples you want to give, et cetera, et cetera?
Questions.
So, good question. Yes.
What about the old DNR? Are they legal?
They're legal. They don't give a lot of guidance, right? They're legal. I mean, it's a lot better than not having anything.
But a PULSE is better to have.
A PULSE is for the ambulance only.
Okay.
What's the
Basically
DNR?
for emergency medical technicians.
DNRs do not resuscitate.
Oh, okay.
That the hospitals recognize that.
Yeah, they do.
As being legal. And most of the DNRs will have are kind of what you were saying. Do you want a feeding tube? Do you want to be intubated? Do you want antibiotics? I mean, they're pretty specific. It's not just don't bring back to life. They're pretty specific.
Got it.
Well, the ones I've seen, when you come to the hospital, they ask you if you have a living will. And if you say no, they give you this one paragraph general thing, which may be sufficient, may not be sufficient. To me, the more information you give, the more you really take some pressure off whoever's making those decisions, and B, more likely what you want to happen or not happen is what's going to occur. So the whole point is to really give guidance as to what you want. And there's no one right answer. Everybody's different.
And the most important, speaking from the medical point of view, the most important thing is to assign that position to someone who agrees with you.
Yes, it's very hard if someone has a different philosophy, and even though it's in writing, I mean, I've seen that. The parent meets with the lawyer, comes up with A, B, and C, and leaves the two daughters together in charge. And A, they may not agree, and there's no third one to break the tie. So that's a mess. And B, they may just not be able to bring themselves to follow through. So it's good to not only do the document, but really to have a discussion with the person that you're assigning and make sure they're cool with it and they can do it.
And it's something you really can't put off. I know my sister could not talk to my dad about it. Absolutely could not talk to him about it. So I became the power of attorney for his health, or whatever the legal term is. Because with my medical background, he knew that I would do what was right. And like, as I said, my sister couldn't even talk about it when everything was good, much less, in a harrowing moment. So it really has to be discussed fully with whoever that you want to have that power.
I totally agree. It's hard. A lot of parents, you say, well, we really need to make sure you've planned, for potential long-term care, all these other things. And you want to have that discussion. Well, of course, my mom's the opposite. She must have told me 100 times where everything is located, but that's fine. But other people, they say that's none of your business. We're fine. We don't need your help. You get those kinds of things. And it's like, no, you're not always going to be fine. We all mature. And there's a point in time where you need some help. And who better than your children, for example? And it's very hard to have that conversation with some people. They're really offended. They don't want to address it. They don't want to think about it. But, I had this case where one of the people right when we were negotiating the settlement, the father, who was a lawyer, died. And guess what? He didn't leave a will.
Boy.
But we figured they were each going to get about $1 million. There was a son and a daughter. And in family law, you may not be aware of this, if you inherit money in New Jersey, it's different laws in different states, that money is exempt from equitable distribution. In other words, the spouse, if you're not divorced yet, does not get any of those monies. And in fact, it doesn't matter when you get them. As long as you keep them separate, the spouse is not entitled to them. But the reasonable income from those assets is counted and is used to determine appropriate alimony and child support.
Uh-oh.
Right. So it gets to be very interesting. So very quickly, because I don't want to keep you forever. So my first question is, what are the circumstances when you should not leave your assets to your spouse? Anybody know?
When they're incapacitated.
Correct. If there's a chance, if they're already on Medicaid, or there's a reasonable chance they'll be on medicated. Now, you cannot cut a spouse out of all your assets. You must leave them what's called the spousal share, which is sort of complicated. It's essentially if you take both your assets and the spouse's assets and divide it by 3, and then you subtract the spouse's assets from that, that's the spousal share. So they have to have at least 1/3 of joint assets. Now, I had a case where the guy was already had Alzheimer's for 7 years. He was not competent, and it was going to mess up his Medicaid that he was already on. So we left the spousal share to what's called a testamentary third-party special needs trust, which gets all complicated, and we'll talk about it. But that's the whole point of seeing a lawyer, is that when you have those kinds of circumstances, that gets addressed. Okay, why do I tell people you should review your will and other planning documents every 3 years? Any comments?
Things change.
Yeah.
Health situations change.
So personal
you inherit from a cousin, you don't know.
Right. So personal circumstances change commonly, and the law keeps changing. I'm going to be floored if there's no change on estates in the next 3 years. And they could be very significant and could impact For example, in December of 2019, for this whole COVID thing started, a law was passed that provides anybody inheriting IRA or retirement assets, they have to cash them out within 10 years. And I had just done a very complicated trust providing for, this guy had 3 million in IRA assets and was anticipating getting another 3 million from his parents who were already in their mid 80s. And he didn't want his two children that were 19 and 20 to get that kind of money. He wanted them to finish college. He wanted them to, be productive citizens.
To work.
Right. He wanted them to work, but he also wanted them to know they had a steady flow of income throughout their life. And his brother was a CPA, and he was willing, of course, to be the trustee. All worked great until the law got passed. So he and I had a conversation as what can and can't do now. But that's the point. The law changes and your circumstances change. It could be a 10, 15-minute call with your attorney that did your documents, and they can ask some questions, you can ask some questions, and maybe there's nothing that needs to be done, but you should check in every 3 years. Okay. Why can't I do a will on a form on the internet, besides the fact that I don't get any money, which I don't like? Anybody know what is the practical reason? How about a case I literally had in the last 2 years where they decided not only were going to do their will from the internet, they were going to have a will party with other neighbors that did the same thing. So they got the wine, the cake, the whole bit, right? And they print this page and a half form that had blank lines, like for where you put your name, things like that, right? So where you say I and you put your name, the wife in question wrote her name in script, like a signature. And where it says, you, the testator, sign here, she had the notary sign in that spot. She didn't sign at the bottom. And then she gets cancer and regretfully dies. Husband, and of course she named her husband as the primary beneficiary. He goes to the surrogate and said, we're not accepting this. This is not a proper will. He's like, this is ridiculous. Well, he comes to see me and he says, there's no way I'm going to have a problem here. I said, oh, I don't know. He says, her sister is always talking, and her mother always talking that she promised them the house or whatever. But, they're never going to come up with the money for a lawyer. Well, what a lot of people don't realize is there are lawyers out there. I'm not one of them, but there are lawyers out there that will do a will contest on contingency, because if there's any argument at all, they will be granted legal fees from the estate. And that's exactly what happened here. For not spending, say, $1,000 to get a will done, he spent $72,000 on settlement and $12,000 on legal fees. I don't think that's a good cost-benefit analysis, do you? So a lot of people tell me, oh, well, I just did my will from the internet. And I say to them, oh, what did you do about the per capita and per stirpes issues? And they say, what's that? I said, if you don't know, you didn't address it right.
Yeah, but what about medical directives, living wills? Can they be done independently and still be, considered legitimate?
Well, if it's done in a format that's a proper format, it will be considered legal. Mm-hmm. The question is, have you really thought of everything? Do you have expertise in all these issues? Isn't it better to really be sure it's formatted correctly and that every issue is really addressed properly? But certainly there are forms out there and, that you can use and may in fact be fine. I don't know. Of course, I can't help myself. I'm a lawyer, and I happen to think we bring value to the table. And you think, oh, I can't afford it. Really? To do a living will for two people My fee is $275. Really? You can't afford that? Come on. So, I mean, for me to be really sure that what happened, what I want to happen happens, to me, that's worth it. But everybody is entitled to their own opinion. I mean, you can do your will. You can literally handwrite it. There's a case in New Jersey where a guy decides to commit suicide and he proceeds to write a will on his cell phone. And with no signature, but of course you could tell when it was done and everything else, court upheld that will. I think that's really weird. They wouldn't take the will that they screwed up from the internet, but they took this cell phone will. I wouldn't want to count on that. Okay. Do you want me to stop or keep going?
Oh, keep going.
Okay. All right. Who wins? The beneficiary on an asset or those named in the will? And Paul, you can't answer. So what overrides the other? A beneficiary designation on an asset or what's in the will? I'm not getting a lot of answers here.
Well, I'm going to guess what's in the will. I haven't heard of a
Wrong.
beneficiary on an asset.
The beneficiary designation on an asset wins.
Oh, okay.
Oh,
So,
What's a beneficiary designation on an asset?
well, let's say you have an IRA and you say, I want
Oh,
the
I see.
beneficiary to
Okay.
be my spouse and I want the contingent beneficiaries to be my children. That's what's going to happen.
Okay.
For
Yeah,
those money.
I understand. I was thinking more of, who gets grandma's clock? I was
Oh,
promised.
no.
Okay.
That you can't really do a beneficiary designation on that.
Okay.
Okay. Can I be liable for my spouse's long-term care expenses? Yes, yes, yes. For my living mate's expenses? No, no, no. What about my children? Could they be liable for my long-term care? Well, that's a little more complicated to answer. There is actually a law on the books of New Jersey that says yes. I have never seen it, no, and we've discussed this in the elder law section. This hasn't happened yet, but there was a case in 2019 that Pennsylvania, which has a similar law, they actually enforced it and held liability for long-term care expenses against the children.
I dated a guy who was doing it was responsible for his grandmother.
Wow.
Yeah. His parents had died and the grandmother was still alive and they hit him for the bills.
And they live in New Jersey?
Yep.
Wow.
It was a few years ago.
I'd have to see all the circumstances.
Yeah.
So, I mean, it definitely has happened legally in Pennsylvania. I'm not aware of a case that has happened yet in New Jersey, but it's a very good argument for planning, including buying some appropriate products that are likely to protect your children. And traditional long-term care products, the problem with them is of course, they get quite expensive, number one, as you get older. And number two, it's as you get older, when you're 40 and you're perfectly healthy, it's impossible to imagine that all these parts stop working so perfectly. But when you hit 50 and 60 and 70, you start to realize, oh, right?
Yes.
So, if there's lots of ways to get long-term care coverage. Now they have life insurance policies and annuities that have long-term care components. And all this can be discussed with Paul Ona. She's very, very knowledgeable. And, he doesn't only sell one product, so he can really figure out what would be best for you. So you save money.
He's an awfully nice guy.
that's what I
Agreed.
I agree with that also.
Don't believe everything you hear.
At least understand what's at risk and what your options are. Then you can make an educated choice. I don't sell any products. I don't have any affiliation with Paul Onish other than I'd like to think we're friends. But so when I recommend something, I don't have any personal interest in it whatsoever. And that's important to me that I don't. And I'm only talking as a lawyer when I talk about those kinds of things. So we talked about what happens if you leave money to a person you live with. Well, if they're a domestic partner, they're in luck. If they're not, they're out of luck. They're going to pay taxes, inheritance tax. So,
Gabrielle, is a domestic partner the same thing as a civil union partner?
No, a civil union is treated more as a straight marriage. Okay. And all the laws have been adjusted to treat them exactly equal as a marriage, a spouse.
Okay.
Any questions?
Does it cost to get when you have to file for that for domestic partnership?
There's probably some filing fee, but I'm sure it's under $100. I mean, we're not talking a big deal here.
Okay.
I mean, I don't know exactly. I've never done it. I happen to be married, so I don't know. I have done a domestic partnership, a divorce. That was interesting. As I said, there's different rights for a domestic partner. For example, they're not necessarily entitled, they're not entitled to alimony. Doesn't matter what the facts are, they're not entitled to alimony. But there may be equitable distribution if there's joint assets or whatever. So it's an interesting area.
Is that kind of a new option? I don't think I ever heard of that. That might do for a lot of older people.
Exactly.
That, you know, the kids don't want the parents to get married because they're afraid they'll lose their inheritance.
Correct. A domestic partner doesn't have a right to a spousal share like a spouse or civil union partner does, but it gives you the option if you want to leave some that they're not going to have to pay inheritance tax. So it is a good solution when you have children concerned about that because you don't have to leave them anything.
I had a question. It may be just slightly off topic, but I was wondering if you ever heard of or had experience with an ethical will.
I've heard of it. I've never, nobody's come to me to do it. So I haven't really looked into it and I couldn't really speak about it for that reason.
Okay, I was just curious.
What do you understand about it?
From what I understand, it's a method by which people can leave, setting their material assets aside, how they could leave their legacy, their life philosophy, codes of personal conduct, that kind of thing, if they want to pass that along. So I've seen templates that are just, 3 or 4 pages maybe, and, you could sort of, fill in, pre-filled in questions or, things of that nature. But the interest for me was because that's kind of what I've done for people and continue to do for people. But I do it in a video documentary format so that they can leave their legacy and their thoughts of life and things to their families. And I know some people have actually accomplished, personal video wills. Have you ever come across that?
I haven't, but it strikes me as potentially being valid. Probably a court would have to, look at it. I mean, I would think that it will have to go to a judge to get admitted because it's not a standard format.
Right.
And you just have clerks at surrogate dealing with you. They're not going to make legal decisions. So the surrogate of each county is an attorney.
Right.
That sounds like something you'd see on television.
But
well, appropriately enough. No, I think if people do it, they do it in conjunction with the appropriate documentation.
well, yeah, I mean, let's say somebody is, quite ill and they're not doing, I definitely very commonly, I have people that don't do the traditional thing, everything to my spouse and then, then to my kids kind of thing. And I've had people specifically cut out certain children in their will. And what I do in those cases, I put in some language. I try to be very tactful as to the reason that they're being cut out. So it's really clear that the person, and I might even add language, I've thought about this at length and blah, 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 so that it makes it much, much harder. And I also put what we call a no contest clause in there and so forth to make it very difficult for that child to contest the will, successfully at least. Anybody can contest anything, but successfully.
I've heard that if you leave $1 to the people you want to cut out, at least you've recognized the fact that they exist and you're giving them $1.
Yeah, I mean, I think that was more in favor a number of years ago. The more important thing is to make it very clear, what your thinking is and why you're thinking the way you are. Whether it's valid or not doesn't matter. The point, that's how you see it. It's your money, your life. So you could do whatever you want.
Gabrielle, could you go over the next to the last bullet?
Oh, yeah, sorry. Okay, so here's Class A beneficiaries, and there are surprises in here. Parent, grandparent, spouse, of course, your child, okay, grandchild, great-grandchild, stepchild. Isn't that interesting? For a long time, the only way we could get a stepchild to receive money without tax is we would have the potential decedent adopt that do an adult adoption. Totally not necessary. However, a step-grandchild is not a Class A beneficiary. Look at this next one, mutually acknowledged child. Boy, that would be fun. I've never had that case, but that would be interesting. Of course, civil union partner and domestic partner. So those are your Class A beneficiaries. I think I have. Now, in contrast, here's Class C. A brother or sister is a Class C beneficiary. That means they pay estate tax. A spouse or surviving spouse of a child of a decedent. And if it was a surviving civil union partner, right? So if the man, for example, in a civil union, if dies and that's your child, the surviving civil union partner is going to pay inheritance tax. They're not going to be, and the same is true that if you have a spouse of your child, if you want, I have seen people have very close relationships with their daughter-in-law, for example, but they're going to have to pay inheritance tax. And of course, there's the catch-all that we always have in every law. Class D, anybody else we haven't thought of? I don't think I have any more. I think that, oh, here, this is the actual code for your reference. So you can see the code numbers. So that's the deal. And my hope is that you found this educational and thought-provoking. And if you haven't already done your planning, that you will be, with whoever it is, very much triggered to just make it happen.